Welcome to all of you who've taken the time to join us today. Before we get started, for any press who may be in attendance, I just want to note that this session is off the record. So today we'll be hearing from two experts in the field of ERISA litigation, Alison Douglas, a partner in Goodwin Procter's ERISA litigation practice, and her associate, Christina Hennecken, who's also a member of Goodwin's ERISA litigation group. Alison and Christina will be sharing their insights about plan sponsors' roles and responsibilities under ERISA generally, and in particular, some of the considerations that plan sponsors should be bearing in mind as they evaluate various potential plan investment options. So we'll start things off with Alison and Christina providing a high-level overview of a plan sponsor's duties under ERISA. So over to you, Alison and Christina.
Thanks, Kevin, and thanks very much for having us today. In our practices, Christina and I represent defendants in a lot of the 401k plan litigation, and it's actually just really nice for us to kind of get out of the trenches of litigation to get a chance to participate in a discussion like today's with folks who are really in the industry and shaping the industry. I think we're on our first slide here, and before we kind of get into our discussion today, what I wanted to do is just give an overview of ERISA's fiduciary rules. I'm sure lots of folks that are watching today are very familiar with these, so we will keep it brief. ERISA, of course, is the federal statute that governs employee benefit plans, and it imposes really a comprehensive set of rules on fiduciaries who make decisions for plans. So the rules at a high level are first the duty of loyalty, which requires fiduciaries to act exclusively in the interests of their participants and their beneficiaries. Then we have our duty of prudence, which requires fiduciaries to act prudently, which essentially under the law means that they must act with care, skill, and the diligence that would be exercised by a prudent person under similar circumstances. ERISA also requires fiduciaries to follow the plan documents, which might seem relatively straightforward, but is often an issue in litigation and something that we like to keep top of mind when we advise our clients. And fiduciaries also have an obligation to diversify the plan's investments so as to minimize the risk of large losses. And that's really kind of the four guiding principles, I would say, for fiduciaries under the statute. And while these duties have been interpreted as some of the highest duties imposed under the law, I would say that the good news for fiduciaries is that ERISA also gives them some protections. One of the most significant protections under ERISA for fiduciaries is the safe harbor that we reference here on our slides. Under ERISA safe harbor, which is at section 404C of the statute, fiduciaries are protected from liability for a participant's investment losses so long as the participant exercised control over her own plan account. And for participants to be deemed to have exercised that control, they must be given a broad range of investment options to choose from and really enough information that they're able to make informed choices. So the idea of making a broad range of investment options available to participants is very relevant to some of the concepts that we're going to talk about today and some of the litigation trends that we're seeing. So I wanted to make sure we noted that up front. And that's really the basic legal framework that governs fiduciaries who are responsible for choosing investments for their plan. I think the real question and what we kind of want to get into today is how are courts applying these rules to actual fiduciary making decision now that we're some 15 plus years into a very significant trend of litigation around 401k plan investments. So I'm going to turn it over to Christina to give kind of a little overview of a paper that we wrote that was sponsored by our colleagues at T. Rowe Price that kind of gets at that question of how are courts wrestling with and applying these rules that I've just described. So I'm going to turn it over to Christina. Maybe with that, we can move to our next slide.
Thank you, Alison. There we go. So like Alison said, in the last 15 years or so, there's been a lot of cases, hundreds of cases filed against plan fiduciaries, challenging 401k plan fees and investments. And as a result of all this litigation, we have lots of decisions. There have been dozens of cases where judges have weighed in on these issues. So what Alison and I tried to do in our paper was to tease out some key takeaways that we thought would be helpful for fiduciaries when they're making their decisions about their own plans investments. So the slide shows three main principles from our paper. And the first one is that it's all about process. courts have confirmed over and over again that fiduciary prudence focuses on process and not investment outcomes. So essentially, courts have recognized that investment outcomes are unpredictable. Even the most diligent fiduciary can't predict market behavior. And for this reason, courts have been hesitant to judge fiduciaries based on investment results that are only knowable in hindsight. So rather than focusing on those outcomes, courts look at the process that the fiduciaries had when they were making their investment decisions. And generally, so long as the fiduciaries had a good process in place, their investment decisions are likely defensible. And the second principle on our slide is that fiduciaries should focus on the value for cost proposition. And what we mean when I say this, when we say this, is that when fiduciaries are comparing different investment alternatives, it's important to remember that there are lots of dimensions to any investment product. And when you're comparing products, you have to make an apt comparison. That's really important. Something Alison and I see in litigation all the time is plaintiffs making comparisons that aren't apt comparisons, such as comparing active and passive strategies, or challenging a fund and comparing it to a different fund with a very different underlying asset allocation. And we've seen some courts push back on those kind of comparisons. And then the third principle is that providing a range of choice to your and investment strategies to your plan is entirely appropriate. So participant choice is really a hallmark of defined contribution plans. And courts have recognized that ERISA doesn't mandate any particular mix of investment options, and it doesn't preclude certain strategies. ERISA doesn't prohibit the use of active management, for example. And we've seen a number of courts have in fact dismissed cases where plaintiffs challenged a particular investment option where the plan offered a wide range of options at different price points. So those in general are just three of the main principles that we talked about in our paper. I'll turn it over to you, Kevin, for our Q&A.
Thanks. Thanks for the great overview of the sort of general fiduciary ground rules that govern plan sponsors' decisions. I'm wondering whether you can talk a little bit about kind of the day-to-day context that plan sponsors are operating in today. You know, we hear a lot, for example, about litigation, fear of litigation that's driving plan sponsor behavior and decision making. Be interested, Alison, maybe you can kind of react to that a little bit and see what your interactions with your clients have been recently.
Sure, no, I certainly, hearing a lot about litigation concern lately, frankly, it's what's keeping Christina and I in business, but I do have some concerns about how much I'm hearing in the industry about fear of litigation, because I guess my general reaction to that is that making decisions, if you're a fiduciary and you wear that, kind of serious fiduciary hat where you're supposed to be acting in the best interest of participants and engaging in all the steps that are required for diligence and prudence, making, decisions that are kind of just based on a fear of litigation can actually be inconsistent with ERISA's fiduciary obligations. And I don't know that folks really appreciate that all the time. Under the duty of loyalty that I talked a little bit about earlier, courts have said fiduciaries really have to act with an eye single to the interests of their participants. So it's a very onerous standard to be acting exclusively in the interest of participants and beneficiaries. And while it might seem an obvious point, what it really means is you can't, as a fiduciary, act out of self-interest. So the idea of kind of making knee-jerk decisions or having knee-jerk reactions to litigation trends, troubles me because it doesn't make for good decisions. And really for a couple of reasons. First, as I alluded to, it's not acting in the best interest of participants. And we see that playing out in litigation. In the context of litigation, a spotlight is really shined on kind of what fiduciaries were thinking and what they were doing. And there have been cases that have examined kind of the motivation behind decisions. There was a case some years ago involving the decision to eliminate a company stock fund. And when the court really examined what the fiduciary's process was and what they had been considering in their decision making, the court realized, and kind of what came to light during discovery, was that the decision, rather than being based on kind of a reasoned process around the merits of the investment, was really just motivated by a kind of a pure fear of liability and the potential kind of litigation risks around the investment. And the court said, hey, that itself is a breach of duty, to just be worrying about your own hide and not kind of doing what's in the best interest of participants. So, being motivated by self-interest can itself be a breach of duty. That's kind of why I think the knee-jerk reactions to litigation don't really work. I'd say the second reason, from more of a litigation perspective, is that making decisions trying to avoid litigation doesn't seem to be working practically either. And that's really just because, as Christina said, we're 15 years into a trend that has attracted a wide range of plaintiff firms to bring suits concerning all kinds of issues. And there's really no particular set of investment options that can completely immunize fiduciaries from liability. What we saw 15 years ago when these cases were first filed was kind of a cookie cutter approach, challenging the use of mutual funds in 401k plans, arguing that there should be only institutional products, kind of a very fee-based set of allegations. And then the litigation landscape has really shifted. So as the market's moved and more institutional products have come into plans, there are now litigations challenging the use of institutional products. There are complaints challenging the use of index funds, whereas the original complaint said you got to use index funds. So it's always a shifting landscape. We've seen that with kind of across the board. There were cases that were challenging the fact that a stable value fund was offered, for example. Now there's cases saying, well, you have to have a stable value fund and you can't have a money market fund. So the idea that fiduciaries are going to change their plan to be reactive to litigation trends, I don't think that works practically, and I don't think it's a good idea from sort of a fiduciary perspective. My biggest takeaway from the trend recently is that there is no silver bullet. So fiduciaries really do best to kind of follow first principles of focusing on process, as Christina said, and not just kind of running away from the litigation issues du jour. I guess I would also add on this point, Kevin, that there's kind of another misperception, I think, around what sponsors should or should not be doing to minimize their own risk or burden, which is this concept that I often hear. If I just move to an all index lineup, not only do I not have to worry about litigation, I really don't have to worry about kind of all the burden associated with overseeing my plan. And that, I think, troubles me as well, because again, fiduciaries really shouldn't be making decisions trying to avoid litigation, but they also shouldn't be making decisions just trying to avoid sort of administrative burdens that are associated with the really important job of running a plan. So the idea that you would change your lineup just to kind of minimize work, I think kind of exposes you to a different set of risks. I also don't think it probably works, because as those of us in the industry know, there's work involved in overseeing any kind of investment, including passively managed investments. Lots of different providers out there. You still have to engage in the requisite diligence to identify providers and oversee those funds. So I'm hoping that these litigation trends aren't having too much of an impact on kind of the bread and butter work, day-to-day work of fiduciaries. But it's certainly a fair question, and that's kind of what we're seeing around that, Kevin.
Right. Well, I guess there's some irony in people being subject to litigation because they were worried about litigation. But it just underscores the point that you made, which is, look, it's as you said, it's an important it's a critical role that you play as a plan sponsor that comes with a lot of duties and obligations, and trying to get away from those, whether it's because you're worried about it either doing too much work or you're worried about ending up in court. You need to keep the focus on the plan participants and their best interests as a risk requires. So
exactly.
Thanks for that. So Christina, maybe turn to you for a moment and ask about some of these cases that Alison mentioned and what the takeaways there are about how plan sponsors should be thinking about their investment fees in particular. And I'm wondering, some of there's a wide variety, obviously, of types of plans out there, wondering whether there's any differences between the takeaways as those would be applicable for, say, a larger plan versus a smaller plan.
Sure, got it. So as we've been saying, ERISA focuses on the process the fiduciaries take, whether they're selecting an investment option or evaluating investment options that are on their plan lineup, and that process considers investment fees. Something Alison and I see all the time in the case law is that plaintiffs will challenge the inclusion of a particular investment option or several options based solely on their fees. They'll claim that the funds are more expensive than other options available generally in the market, like index funds, and based on that comparison and the difference in fees, that the choice to include the more expensive fund must have been imprudent. And some courts have recognized that, like I mentioned this before, that these can be apples and oranges comparisons, comparing an actively managed fund and a passively managed fund, for example, funds with dissimilar investment strategies. But of course, it depends on the case, depends on the specific funds being analyzed. But a common theme coming out of these decisions is that fees are just one dimension to a plan's investments. And fees should not be the sole basis upon which an investment selection decision is made or judged by a court. As one court put it, ERISA does not require fiduciaries to scour the market for the cheapest possible funds. Fiduciaries have a lot of discretion and flexibility under ERISA in choosing investments that are best for their plan. You also asked about large plans versus small plans, but the same rule applies regardless of plan size. It's true that historically these cases have focused on large plans. Until recently, we only saw generally plans with over $1 billion in assets getting sued. But more recently, there's been new entrants to the plaintiff's bar, attorneys new to ERISA litigation that are moving down market and have sued smaller plans. So now it's no longer unusual to see a plan with less than $1 billion in assets be subject to ERISA litigation. And while still pretty rare, we've even seen a handful of cases against plans with as little as $10 million in assets.
Wow. And I just want to remind folks that are listening, we are fielding questions through the chat box, and if you've got them, please feel free to submit them as you go along. We've reserved some time at the end to address those questions. So if you submitted one and it hasn't been raised yet, we will get to them, at least as many as we can, toward the end of the presentation. So Alison, back to you maybe, and could I ask you to speak a little bit about what courts have said regarding a plan sponsor's duty to monitor those plan investment options on an ongoing basis? You know, for example, what's the role that an investment policy statement might play, or a watch list process, some of those sorts of things?
Sure. I mean, certainly these are all issues that come up frequently in the cases. And I'd start by saying, you know, courts certainly agree there's a duty to monitor the designated investment options in a plan, which is a little bit of a legal concept, but options that have been formally designated for the plan need to be monitored. There can be options that are available to a plan that are not designated investment options that fall into a slightly different category. But with respect to the kind of ongoing duty to monitor designated investment options, you know, what's really interesting, I think, about the litigation is that generally participants who are bringing these suits, and certainly the lawyers that are bringing the suits, don't know anything about what fiduciaries are actually doing to monitor investments, right? So they're generally completely speculating in a complaint that anything's being done wrong. Maybe they can tell they get their hands on a summary plan description and they can tell that there's an investment committee. Maybe they can glean something about who a plan administrator is from a publicly filed Form 5500, but generally they know nothing about the actual process. So the complaints don't tend to say anything about the detail around what is being used in that process. And it's really only if a case gets past kind of a motion to dismiss stage that more information about how the plan is managed is going to come to light when parties kind of get into the discovery process and meeting materials and minutes are handed over. And a lot of cases, don't even get to that stage, but if they do, then it often becomes kind of a battle of experts opining on, what a quote good fiduciary process should look like. But what I would say is that for the most part, courts have recognized that there is a wide range of fiduciary practices, and they've been really hesitant to kind of wade into the details around how plans are managed very specifically, which I think is frankly good for fiduciaries, because I don't think that's what we want our courts to be doing. I don't think we want our courts to be mandating how investments are evaluated and reviewed. But it's certainly something that the plaintiffs bar is trying to put in the crosshairs. So, you mentioned, Kevin, a couple of things like investment policy statements that really do feature often in the litigations. And I would start from the kind of basic principle that the one thing I think courts are very clear on, ERISA doesn't require an investment policy statement, right? So the idea that there's a dispute about, what your investment policy statement looked like, or did you follow it, et cetera, like we have to remember kind of our baseline proposition that ERISA doesn't require you to have a specific investment policy statement. Things like watch list processes that sometimes people choose to put in an investment policy statement, ERISA doesn't require that either. So, I'm not aware of any court that said you have to have a specific investment policy statement or you have to have a watch list process. And certainly courts are not kind of getting into whether either a specific kind of fund review criteria that should be utilized, or what benchmarks should be used, or what periods of performance data should be looked at. I think so far courts are appreciating that their job is to kind of make sure that the folks in the positions of overseeing investments are, aware they have that responsibility, have an appreciation for the importance of the responsibility, and have put a reasonable process in place. And so, on the one hand, we're not seeing coming out of the cases very specific checklists that fiduciaries should be following. But I think that's a good thing, because I think there can be a range of practices and it can depend on a whole host of things. And I don't think ERISA was designed to be that prescriptive. So, what we do see is more lessons from the cases around, what can get fiduciaries in trouble. And certainly, if you're doing something that's not consistent with your plan documents, if you have an investment policy statement, but you don't follow it, those are certainly going to be some bumps in the road in litigation for sure. But what I focus on is a lot of the learning we're getting in litigations, from the industry itself. As I mentioned, we have expert witnesses that will be working with both sides in these cases. And what they bring to the court is kind of real life experience around what fiduciaries are doing and what proves to be good practices. And you often hear from the consulting community that very prescriptive investment policy statements or very strict watch list processes are kind of falling out of favor, because fiduciaries really should have some flexibility in how they manage their plans. And as a lawyer, I agree with that from the perspective of the sort of hallmark of fiduciary status under the statute is discretion, right? So if we're implementing very prescriptive measures that kind of tie the hands of fiduciaries, I don't think that's consistent with ERISA and sort of the goal of giving fiduciaries the discretion to do what's best for their participants under the circumstances that they encounter, which can vary depending on market cycles. So, I sort of like to hear that the industry is pushing back a little bit on this idea of having very prescriptive watch list processes. And I've not seen a court say, oh, you have to do it this way or that way. And that really makes good sense to me because of that core concept that fiduciary should have discretion. So, we're not really seeing courts trying to micromanage the fiduciary process. There have been, Christina mentioned there's been hundreds and hundreds of these cases filed. I think there was a couple hundred just in the last 18 months, which is really remarkable when you think about it. But very few cases kind of get to the fully developed stage of going to trial. Probably less than 10, maybe less than 7 have gone to kind of a full trial on the merits, where a court is listening to witnesses, hearing what the exact process was, and having an opportunity to kind of weigh in on that. And in the instances where we've seen that, very often we're seeing defendants get, full defense victories because they're able to demonstrate that they were diligent, they were thoughtful, they utilized outside experts when needed, not always, but they weren't perfect, and I haven't seen a court require perfection of any fiduciary. What I do see them say is kind of high level things like there was a trial last year in a case concerning a large 401k plan where the court concluded that the fiduciaries had appropriately monitored, I think it was a set of target date funds that was at issue in the case. And the court wasn't getting into the weeds on very specific fund review criteria. They were saying things like, okay, the committee met quarterly, they looked at historic performance, they looked at peer group comparisons and were comfortable that it was a diligent process. And I think that's kind of directionally what we're seeing from the courts. And I would be very surprised if we see really, prescriptive or proscriptive guidance coming out of these cases, which I think should give fiduciaries some comfort that if they're attacking these things with the right mindset, they're putting in the time, that there is still some flexibility in how they manage their own plans.
Right. And I guess it goes to just that general adage about, look, if you say you're going to do it, you better do it. So to the degree that you do choose to enact, whether it's watch list or investment policies or whatever it is, then you need to abide by them. But from what you're saying, very broad discretion given to the degree to which you do want to implement those policies or what they might look like and that sort of thing.
Exactly.
Great, thanks. So Christina, I want to go back to you and something that you said or that you alluded to in your introduction, which was that ERISA doesn't preclude, as far as fund selection, it doesn't preclude the use of active funds, for example, and that's not really, it's not an either or choice between active and passive strategies, not active versus passive. And the plan sponsors instead should be focusing really on the value for cost rather than simply seeking the lowest cost investment option. And can you explain a little bit more kind of what you mean by that and what the factors are that courts are focusing on there? And then in particular, is there any, I'm curious whether there's any DOL guidance that directly addresses that point, sort of active and passive and that sort of thing.
Sure. So when we say value for cost proposition, it's something that comes into play when the fiduciaries are considering different alternatives. Courts have recognized that there are several dimensions to any investment product and that these different factors impact the fees and the costs, and that's relevant. For example, you can have different types of vehicles. You can have mutual funds. You can have collective investment trusts. For example, you can have different asset classes, different management strategies, like you said, active and passive. And all these factors impact investment options costs. And that's relevant when evaluating the fiduciary's process and how they looked at those funds. You asked about Department of Labor guidance. So even though a lot of these lawsuits focus exclusively on costs, the Department of Labor has actually said that fees are just one of several factors that should be considered when you're evaluating alternatives. Along these same lines, just like ERISA doesn't mandate any particular mix of investment options, the Department of Labor hasn't mandated or prohibited using any particular mix using active or passive strategies. Actually, the Department of Labor discouraged Congress from requiring specific investment options to be included in retirement plans back in 2008. Congress actually considered mandating that all retirement plans include one index fund, and that proposal failed. But when the Department of Labor was speaking to Congress about that proposal, they expressed concern that requiring specific investment options would limit the flexibility of employers and employees working together in designing their plans and best serving their needs for the plan. And generally, courts have followed the Department of Labor's lead on that point. Some courts have even said that fiduciaries must consider features other than price. And like I said before, courts have recognized that when you're comparing different investment options, it's critical to make appropriate comparisons. And all those factors I mentioned a few minutes ago are relevant to making those comparisons.
Right. Thank you. Thank you. So there's a lot of focus at the moment on ESG and the proper role for ESG within asset management. And I know the DOL, or I think I know the DOL sort of recently did a bit of an about face from the prior administration in their stance on the appropriateness of plan sponsors taking ESG factors into account when they're selecting and vetting plan investment options. So how does that relate to the views on whether plans should be using active strategies, for example? And Alison, maybe I'll direct that one to you.
Yeah, sure. So, I mean, I would say, look, it's obviously an evolving area, but I would say that the evolution of the ESG rule, is somewhat relevant to the active versus passive debate, kind of in a couple of different ways. I'm sure folks on the program know that, the prior administration back in November 2020 had issued a rule regarding what are called financial factors in selecting plan investments, which I always, we're all calling it, we all called it the ESG rule. I don't think it actually talked about ESG in the end there, but the rule required plan fiduciaries to select investments for plans based solely on pecuniary factors rather than any ESG considerations, and ESG factors would really only be considered pecuniary if they presented economic risks or opportunities that could be treated as material economic considerations, and I think, caused some consternation. Unlike the prior rule, the administration's new proposed rule says fiduciaries can consider ESG factors in making decisions about investments. So, for me, how does that kind of relate to the active versus passive debate? I mean, my reaction, and certainly, folks in the industry will have a better insight into this than I will as a lawyer, but my reaction to that is that, active management is probably better suited to addressing ESG issues than passive because, active managers they're just not limited to only investing in companies that are kind of constituents of an index. So, it sort of confirms for me my view that there is a place for active management in 401k plans, which I think, courts have kind of confirmed over the years, under sort of a different thread of conversation. The other thing I would note is, I think it's relevant to this debate that what we don't see in the new proposal is something that had drawn a lot of fire around the 2020 rule, and that was language that was in the DOL's introduction to its 2020 rule, and it was preamble language that suggested kind of a bit of a bias in favor of low-cost funds or even passively managed investments. The DOL had basically said something to the effect of, if plans aren't investing in actively managed ESG, they'll invest more in low-cost and index funds. And I think, the industry sort of fairly said, whoa, that's suggesting some sort of a bias in favor of index, and that frankly wasn't consistent with what courts have been saying about the value of a broad range of investment options being available to participants, and frankly wasn't consistent with what the DOL has historically said, as Christina alluded to, that cost alone really shouldn't be driving decision-making around investments. So, the sort of absence of that language, I think, this time around is something that I took note of. I would also note kind of generally that while the proposed rule has a lot of differences from the prior rule, like the prior rule, it continues to talk about what appropriate consideration is of investments for fiduciaries. And it talks about comparing funds to alternatives. But I think it's really important to note that that language is comparing funds to alternatives with similar risks. And that concept of similar risks is something that we talk about implicitly in our paper, which is the importance of, I think as Christina put it, making apt comparisons, right? So I think embedded in this piece, of the proposed rule and the DOL's sort of vision for how fiduciaries should be evaluating investments is, got to keep in mind, that that you should be making comparisons based on similar products and similar risks. And so I think that it's reflective of what courts have said. There's been a lot of litigation, as Christina alluded to, around just kind of rote allegations in complaints saying, well, we're challenging this fund because it got worse performance than this other fund. And we've really had to educate courts. You got to look underneath the hood. And if they're comparing a strategy that's not really similar in terms of risk profile, allocations, or overall investment strategy, that shouldn't state a claim. And so if it shouldn't state a claim, it also shouldn't be a comparison that fiduciaries are making kind of in their day-to-day work. So, those are sort of the threads that I see in the proposed, kind of in the debate around ESG and the proposed ESG rule that I think do relate to this active versus, passive debate. And in my mind, it just kind of comes back to, make sure you're comparing like products with like products. And I do think that directionally, giving fiduciaries the ability to take into account ESG factors is still directionally signaling to fiduciaries that a broad range of options is a good place to be with participants, because some folks may value those features of investment. And
I think in some ways it's kind of a fit for purpose type argument, right? Which is, as you said, there are plan participants who all they're interested in is the economic return on it, but certainly. I mean, you don't need to pick up a paper to know that, generationally speaking anyway, certainly a lot of younger investors are very focused on social, environmental issues, those sorts of things. And it's something that they put real value on. And as a plan sponsor, it seems like it would be acceptable to want to respond to your plan participants' needs or desires, and be able to provide them some options that they can select from that take that into account alongside the pure investment return. I don't want to go down the road of saying that performance necessarily suffers at the hands of ESG considerations, because I think that's been disproven.
Right.
But I do think again, as you said, making choices available to plan participants, and that there is a role for ESG funds within a given plan, if that's what speaks to participants' need, makes a lot of sense.
I guess on that point, Kat, you make a good point that I think of as participant engagement, right? And so a lot of the litigation has been around, we got to protect retirement savings. Of course, we have to protect retirement savings. Everybody on this call is part of an industry that's designed to protect retirement savings, right? But what the litigation is sort of missing is that a big piece of preparing for retirement savings is getting participants engaged with their plan and with their accounts and being interested in participating. And we defended a client in a trial a couple of years ago where we got a full defense verdict for some very diligent fiduciaries doing the best they could to manage their plan. And while things might not always be perfect for every fiduciary, one of the things the court was very interested to hear was whether investments were being offered that participants wanted. And, we were able to put on evidence that participants had asked for certain investments, and the court was interested in that. And not every fiduciary is going to get that feedback from their participants, but this court was interested to know that part of what was going into decision-making was, were participants going to get engaged with their accounts? Were they going to contribute? Were they going to prepare for their savings? And I think that's something that can't get lost here as an important goal.
Yeah, absolutely. And just to finish out, or to another aspect, I think of that, again, sort of fit for purpose idea with active and passive, they serve different roles, or they can serve different roles within a plan. And, having a broad selection of options there, that reflects that broad set of goals or objectives of the funds, I think makes a lot of sense. So.
Yeah.
Maybe just kind of staying on the kind of guidance to plan sponsors point, any guidance that you could offer to investment on the or actually I should move it over to the investment manager side rather than the plan sponsor side. From an investment manager's perspective, as investment managers are creating products, marketing products, and strategies and whatnot, any considerations that they should be keeping in mind in order to make those funds and strategies kind of more attractive or more useful for plan sponsors who are focused on all these issues that you've been talking about, focused on fulfilling all those fiduciary duties, from a kind of again, in the asset manager standpoint, we want to make sure, and I work for one, we want to make sure that the products that we're putting out there are useful and fit well within these plans. Anything that we and our colleagues and competitors out there in the industry should be considering?
Yeah, I mean, I guess I would say on that I think investment managers in this environment are going to find that sponsors have become much more educated, right? And they're asking a lot more questions. And I do think we can credit some of that to the DOL's disclosure rules from, going back a decade now, that have, kind of elucidated for sponsors what they need to know, both on kind of a fee perspective and an investment perspective. But the litigation's put a lot of focus on whether sponsors understand the products that they're offering. And that might even be more important now, as I mentioned before. Like, I think we can all say we've seen to some extent the market moving a bit more towards institutional products. I mean, mutual funds are still widely used. They're, in my view, very appropriate for 401k plans, and they offer a lot of great features, but they're highly regulated, right? So what information gets put out about them is kind of plug and play.
Right.
Whereas I think as sponsors move into more custom products or institutional products like collective trusts or separately managed accounts, maybe there's a little more room around the edges for investment managers to make sure that they are, kind of communicating what they want to communicate about those products. So I certainly think, it's an obvious statement, but puts a premium on providers kind of satisfying their disclosure obligations so that participants, if they do get sued, can kind of readily point to that they understood the products, they had a reason basis to choose them, and they're making good, decisions around that, and they're better able to monitor the funds when they understand them. From my perspective as a litigator, it's really helpful in the context of litigation if there's been a nice documentary record around what the fiduciaries understood about the strategies that they're offering to their plans, and they had a good, kind of reason basis for why they chose them. We certainly see a lot of focus on that in some of the more recent cases that are very focused on particular investment options. And I think we've kind of moved from generic cases saying, oh, mutual funds are bad and revenue sharing is bad, into more targeted litigation around specific types of investments. And sometimes, for example, there's been a recent trend just challenging the use of target date funds. I think it's been a pretty ill-formed line of attack because you've got cases that say, oh, this provider's target date funds should have been replaced with another provider's, and then the next challenges the other provider. So I think it's a lot of kind of throwing stuff at the wall to see what sticks, but target date funds are an example of a more complex product. They, attract a lot of litigation because as the default option, they're going to attract a lot of assets, and litigation tends to go where there's money. So they've been the target of litigation, and, in the litigation around target date funds, what's I think really been amplified is that there are lots of different dimensions to those products and those strategies. And so, Christina talked about all the different dimensions to just any investment product, but when you think about something like target date fund, or even sort of a suite of kind of style-based funds, even more dimensions there. And it's really important for sponsors to kind of understand those dimensions, whether it's, the type of the sort of type of vehicle it's being offered in, what's the glide path, what's the underlying allocation, are you utilizing, what are you utilizing for underlying managers? And, certainly contexts where we see plaintiffs kind of comparing two different products, often making, inapt comparisons, and courts are starting to recognize that. But anytime that becomes sort of a target in litigation, I think it really puts a premium on asset managers helping their clients to understand kind of the different dimensions to their products, what are the strategies, what are the fees associated, so that sponsors can be making appropriate comparisons. And
I think that's really timely. I'm just thinking from an asset manager's perspective, I can think of two sort of trends that are accelerating, and have been over the past several years, but even more so now. One from a product design or product structure, whatever you want to call it, vehicle standpoint, we're seeing continuing growth of assets in collective trusts, as you mentioned, which, as you said, the rules of the road are not quite as clearly articulated as they are in mutual funds. And so, as you say, that's an opportunity for asset managers to really give the kind of full disclosure that plan sponsors would find useful in meeting their obligations.
Yeah.
Likewise, from a more just kind of pure investment standpoint, because of the continued low yield environment and whatnot, you're seeing a lot of interest in alternative investment classes, which historically have not really been so much the province of. They've been more of an institutional type product as opposed to something that would show up in a 401k plan, for example. But now you're starting to see even direct real estate and commodities, some of these more a little bit more complex asset classes that are making their way into these 401k plans. And again, it's an opportunity for an investment manager who is providing those products to make sure that the plan sponsors have the information that they need to understand what sets those investments apart from a risk profile, from a performance profile, whatever, than your typical equity, large cap equity fund or something like that. So
Right,
it's not
exactly.
to say it's not, there's no prescription against being able to use them per se, but if you're going to do it, you need to make sure that you understand them, is I think what I understand you to be saying.
Yeah, that's exactly right. I mean, I certainly talk to sponsors who like to have components of their plans that can be countercyclical, right? So whether it's like an inflation protected fund or just the ability to offer active management so that participants can have a little downside protection in the market. And so there's very good reasons to have pieces like that in a plan. You just want to have the sponsor who can articulate those reasons and kind of understands the pieces. So
yeah, great
I think
point.
there's a nice role for asset managers there.
Thanks. So we did, as I mentioned, we've left some time for Q&A, and we have gotten some questions. I want to again encourage people to send some more if you have them. We have a couple that are 2 or 3 that I think so far that have rolled in that we should be able to address in the time that we've got remaining.
Yeah, Kevin, I'm happy to jump in because I was sort of scrolling
Please.
as well. I see a couple questions. One I think kind of I'll kick off with one, and then the second one might be a nice tie-in to that. There's a question about whether there's too many investment options in a plan, right? Is there such thing as too many investment options? And it's interesting. I think there's been a number of cases that have tried to argue that, and so far, I've certainly not seen a court say there's such a thing as too many. The market, I think the market trend has been towards fewer options in recent years, but there's still a lot of plans that want to offer choice. And what I think on this particular question, I think the takeaway from courts is there have been cases that have been dismissed at the outset on the theory that so long as a broad range of options was offered, a court's not going to nitpick different funds with different fees or different performance. And so I have read that as meaning broad ranges is useful, right? And can be useful. So I still think we come back to kind of our first principles of fiduciaries having discretion. They can decide what they want as long as they've gone through a reasonable process and have a reasonable basis. I don't think there's any such thing as too many options. There were a number of suits challenging in the 403B plan space, really different model of plan where those plans tended to have multiple providers, and the goal was to make available a lot of options. And I haven't seen, guidance coming out of the courts that have been allergic to that as a concept. I think we will continue to see evolution around this as, fiduciaries become more active, and sometimes, depending on the plan, maybe a more curated lineup makes sense. But I'm not seeing anything that is, I haven't seen anything that suggests that that's a bad idea, right? So it's very facts and circumstances dependent, to be sure. I guess the other question that I thought would make sense for us to address that's kind of closely tied to that is around the Northwestern case that's pending before the Supreme Court, because one of the things the court addressed there is sort of like, well, we've got a bunch of options. We feel, I should say the courts below. It's going to be heard by the Supreme Court shortly.
And just for benefit of people, so this is just a case against Northwestern University it's an ERISA-based case, presumably on the options that were offered in their plan, saying that what was the
Yeah,
gist of it?
and
Was it that it
Christina,
was-
maybe I'll let you sort of tee that up, and I think the question was around whether we can expect any guidance from the court on what might come out of that case.
Yeah, so this case is pretty important because it could impact how trial courts decide whether a lawsuit, when it's first filed, states a plausible claim for fiduciary duty, or whether it states an implausible claim and should be thrown out. And that's important because if the case proceeds, then that leads to costly discovery for the defendant, lots of documents, lots of depositions. But in the Northwestern case in particular, the plaintiffs complained that the Northwestern University plans had too many options, and that that it had excessive fees for its investment options. And the trial court and the appellate court both agreed that the claims were insufficient, that it wasn't enough for the plaintiffs to just say that the plan had not expensive, but had investment options that had higher fees than some alternative funds available on the market. And the lower courts also rejected the idea that it was enough for the plaintiffs to point out that the plan's funds, some of the plan's funds were available as cheaper share classes than the share classes that the plan offered. But as Alison said a moment ago, a big focus of the lower court's decision was the plan offered a broad array of options. The plaintiffs are complaining that some of them had higher fees, but the cheaper index funds were also available. So you can't complain that you didn't have what you wanted. So the case got tossed out, and the plaintiffs obviously have now appealed to the Supreme Court. The issue is not lots, but other courts facing very similar allegations have let the cases proceed. So this has created kind of a split in authority across the federal court system, and the Supreme Court is interested in resolving that. So we might get some guidance from the Supreme Court on whether it's enough to say this plan had investment options that were more expensive than other available options, or whether it's enough to say that this plan offered institutional share classes instead of retail share classes to state a claim for breach of fiduciary duty. So we're obviously keeping an eye on this. It's a lot of industry groups have been focused on it and filed briefs with the court. Oral argument is actually less than a month away now, so it should be an interesting case to see what happens. I don't know, Alison, if you have more to add.
No, I mean, I think that's exactly right. I mean, the share class issue in particular is something we didn't really, touch on yet today. And, it's really more on the fee side, but it's an interesting issue, I think, for kind of fiduciaries and for providers in the industry, because share, the sort of a lot of the debate in the cases is around administrative fees, right? And where the revenue comes from to pay a plan's record keeper. And historically, the availability of different share classes has helped kind of create this economic model where there can be different ways to pay for plan expenses. And courts have understood and accepted the practice of revenue sharing, that you don't have to have kind of a per participant fee. You may have revenue sharing from particular share classes of funds that go to fund the plan's administrative expenses, and that's okay. But what's challenging in the litigation context is if in a complaint, a plaintiff can simply say, oh, there's a cheaper share class available in the fund, and that gets them kind of over the hurdle, off and running in litigation, discovery, millions of dollars in legal fees. That's going to be a real challenge when the fact of that you're not using the lowest cost share class doesn't necessarily mean anything. It could just simply mean utilizing some of the revenue to fund plan administration, among other things. So, we're hopeful that that argument will resonate, that just these rote allegations based on cost should not be enough to state a claim. But, I think that's going to be an issue that might be kind of front and center.
Sounds like it's going to be immensely important, going forward. I'm looking through, we've got a few more questions here. One, I don't know whether, so there's a question or a request to say a few words about prohibited transaction exemption 2020-02, which I guess is the DOL fiduciary rule, maybe. Is that something that you can speak to?
Yeah, I mean, I would say, look, I know the industry is sort of wrestling with, implementation right now. As litigators, that's not necessarily something that we're on the front lines advising clients around. What I focus on with the fiduciary rule and this sort of new exemptive relief is, I think, the expansion of fiduciary status into advice concerning rollovers. As a litigator, I worry about where that goes from a litigation perspective. We're sort of expanding the conduct that could potentially give rise to litigation. And I think that's something that remains to be seen. I mean, that's more what I focus on in our practice is kind of what's the potential litigation risk. And when you have a structure such as this PTE, from a litigation perspective, these exemptions provide kind of a defense to liability. The statute sort of broadly prohibits certain conduct. That's your prohibited transaction. Your exemption then kind of carves back and allows you to do it if you meet certain conditions, and that's how this exemption is set up. What's challenging about that for folks that fall within that framework is you don't necessarily always have an easy out to litigation, because demonstrating that you satisfy the condition of the exemption is something that sometimes requires some development in litigation. So that's what sort of is top of mind for me about this, is we're capturing more conduct in sort of, kind of a prohibited transaction world. And we're going to have folks that are going to be relying on the exemption and meeting the conditions of the exemption. To be sure, there are courts that have dismissed prohibited transaction claims at the outset, saying, hey, it looks to me, based on how this is pleaded, that the conditions were satisfied. And when you've got something like a reasonable compensation condition and the plaintiffs can't plead you didn't get unreasonable compensation, I'm still hopeful we'll be able to, to continue to kind of get some of these claims dismissed at the outset. But I think this framework, I think it's rightly getting a lot of attention, because that's the biggest challenge, I think, with prohibited transaction claims.
Yeah. And I mean, as you're saying, I guess, in other words, I mean, there's whether you win the case is one thing, if it's one of those few that ever goes all the way to trial, but really most of the focus is probably on whether they make it to discovery or not, because if they get over that hump, it becomes it's an immensely costly, time-consuming exercise. And so
that's exactly right.
So if, as you say, you've got to, and if courts are sort of more likely to say, I need to see a little bit more to figure out whether you really ticked all the boxes to satisfy that PTE, and seeing a little bit more means getting it past that first hump into the discovery phase. That changes the ball game entirely.
Really challenging. And what I said before, we've seen hundreds of cases, but only like 7 trials. So what are the rest of the cases doing? Many have been dismissed. Some win on papers at later stages of the case. Lots get settled, right? And they get settled for economic reasons, and not because anybody did anything wrong, but they get settled because people want to move on with their jobs. It's a big distraction to be engaged in litigation, have your fiduciary committee sitting for depositions. So, what troubles me about kind of the settlement trend is sometimes that's moving the market itself. We bake into these settlements all these things we agree to do, fiduciaries are going to agree to do in order to settle the case. And now we're doing things we would have otherwise done if we'd let the market develop, sort of evolve naturally. So,
which takes us back to, your earlier point about people being led by fear of litigation, or their practice being informed by litigation, when in fact, they need to be thinking about, again, what's in the participant's best interest, not what's in I don't want to spend the next 20 months in being deposed.
Exactly.
Mode.
Exactly.
Well, I'm looking here, and I think we're right up against the end of the hour. We did have one additional question. I'm not sure we're going to have time to get to it, about basically discussing the kind of the active and passive building blocks, if you want to call them that fiduciaries should be using when they're creating a diversified, selection of investment options. We're at the hour, and I'm afraid we don't have time to field that one right away, but I think all of our contact information is made available to everybody, and certainly for the IAA, you can always contact Megan or Karen or others to follow up with them. But other than that, Megan, I believe you may still be on. I don't know if there are any last minute things we need to attend to before we wrap things up.
I think Megan's telling us we're good to go, but thank you very much again for having us, Kevin. This was terrific. And we certainly are available if anyone wants to reach out and ask us questions offline.
Absolutely. Thanks, everybody. Take care.